Hello, everyone. Thank you for joining us today. My name is Mike Douglas, and I'm the chair of the BHBA Ethics and Legal Malpractice Law section. I'm delighted today to introduce our speaker, Professor Renee Jefferson. Professor Jefferson is a leading authority on lawyer discipline, judicial ethics, recusal, and democratic legitimacy, serving as the endowed Doherty Chair in Legal Ethics and Professor of Law at the University of Houston Law Center. She's the author of more than 40 scholarly articles and 5 books, including the award winning shortlisted Women in the Shadows of the Supreme Court. And her research has appeared in leading journals such as the Michigan Law Review and the Yale Law Journal Forum. A graduate of the University of Chicago Law School, she previously practiced with international law firms Mayer Brown and Hunt and Williams, and she served as an assistant city attorney for Charlottesville, Virginia. She's also provided expert testimony on judicial ethics before Congress and the Texas Supreme Court of Special Review.
Thank you so much for that introduction. And I really appreciate being here with all of you today to talk about a subject that has been of interest to me as a scholar for many years, and now I think has real relevance based on the headlines we're reading every day. So let me quickly share my screen and we'll jump right into it. So our focus today is when lawyers protest and looking at the from a professional responsibility and ethics angle. As I said, this is an area of law, the intersection of the First Amendment and lawyer speech that I have studied for and researched and written about for nearly 2 decades, inspired in many ways from my years in private practice and as a local government attorney before I became an academic. And even though I'm not still engaged in the practice of law, I still regularly serve as an expert witness and have my hand in issues related to lawyer speech and the First Amendment. But in recent years, we have seen a much more public facing way that lawyers are engaging in their First Amendment rights to speak out. And that's going to be the focus of our time together today. So let me give you a bit of an overview of where we're going, what you can expect, and then we'll dive right in. Lawyers are increasingly visible in moments of public and of public protest and civil action and political expression. And our focus today is really going to be on a timely and practical examination of how professional responsibility rules apply when lawyers engage in protest and other forms of public participation. This is relevant even if you are not a lawyer who is taking to the streets, engaging in traditional sorts of protests and civil disobedience. It's relevant to all of us because as members of the profession, how the public perceives us has a significant bearing on the legitimacy of the legal profession, our courts, and our justice system. And so we will go beyond the question of whether lawyers may protest, of course they can, to explore what the legal profession owes to the public when its members do. Here's how we're going to do this. We're going to examine the ways that ethics duties related to professional responsibility impact public confidence in the justice system. And we'll also be looking at the way these issues intersect with civic engagement. And then specifically, we'll look at some recent real world examples. We'll talk about some disciplinary cases and other consequences when lawyers protest. I'll then turn to a discussion of the American Bar Association model rules. And since I'm speaking to the Beverly Hills Bar Association, the California rules of professional conduct, which really mirror the ABA rules for the most part, but I will show some differences. And then I'll conclude with some thoughts about emerging scholarship and share some different resources for you to the extent you find the issues that I bring to light today interesting and you want to engage more in them. That will give you some pathways forward. I've also provided some written materials of my own that if you want to dive in more, you can do so. And you'll leave our time together with a clear understanding of where ethical boundaries lie, how those ethical boundaries might be shifting or maybe need to shift, and how to navigate public action without jeopardizing professional standing or public trust. I hope I also will leave you inspired to think about what our obligations are, not just to our clients and as officers of the court, but also as public citizens who are part of a profession that is unique in its level of self-regulation and also unique in its level of involvement in upholding our democracy. So this is where I want to begin with a headline that's not so recent, actually. This is from 2007. You might recall at the time this was known as the lawyers' movement. It was a protest of lawyers in suits after the then president of Pakistan unconstitutionally suspended the Chief Justice of Pakistan's Supreme Court. And lawyers took to the streets protesting. When I saw this in 2007, I was just beginning my own career as an academic and beginning to write about lawyer speech in the First Amendment. I found this fascinating. I did not think that I would see a scene like this here in the United States. But I want to turn to some more recent protest headlines. So, moving forward a couple of decades from the Pakistan protest. And this is a clip from the New Republic from this past fall, November 2025. And the headline is Legal Professionals Planning to March Against Trump. Now, the image here is not in the United States, it's in Poland. So you're seeing another example of these kinds of efforts of professionals in the legal profession, whether lawyers or judges, taking to the streets in protest. The photo here was the March of the Thousand Robes in 2020 in Warsaw, Poland. But it's clearly being referenced in the context of protests that we're seeing today. And as this headline from the New Republic notes, recent history has shown that attorneys and jurists can play a big role in bringing the nations back from the brink of autocracy. And the question that we all should be asking is, what is our role in that as members of the legal profession? And that's certainly a question that was asked last May. And there was a call that was answered. This is headlines from May 2025, May 1st, on Law Day, where I was struck by the images I saw because they reminded me of those photos from back in 2007 and the lawyers in Pakistan protesting. But now these were photos from the street corners of every major city and small cities across the nation. These two images, of course, are both from New York City in Foley Square, the location of courthouses in downtown Manhattan. And you have lawyers in their suits and ties protesting on this National Day of Action. One of the commentators, David Latt, said he'd never seen a protest with this many people in suits. And I certainly hadn't in our country. And I wondered at the time, is this an outlier or is this something that we're going to see more of? And I'm here to tell you that it has not been an outlier and that we have seen increasingly lawyers stepping up and protesting, and not necessarily exactly like this, but in different ways. And so let me share some more recent examples with you of lawyers who are engaging in different kinds of protest. We saw this past November lawyers protesting in Maine, and this was in January of 2026 about ICE tactics. Back last November, lawyers advocating in front of the U.S. Supreme Court, protesting rulings of unlawful actions and legal battles against the current presidential administration. We've seen a number of organizations come forward, as some have been launched in recent years that have been backing protest efforts, like Lawyers Marching for Democracy, and I'll share some others in a moment. Here's another even more recent example from just this past February, early 2026. And this is an example not of lawyers taking to the streets and protests exactly, but here's an example of a case where a judge in Texas declared a mistrial after a lawyer wore a T-shirt reflecting protest. The shirt contained images of civil rights movement leaders, including Martin Luther King Jr. and Shirley Chisholm, as well as other protests. And so a different kind of protest, not going to the street, but an attorney engaging in a sort of protest. And this is an example of one of the consequences. And I'll share more as we move forward. It's not just lawyers who are engaging in protests. Our law students are as well. And these are just two examples, one from NYU back in about a year ago in May of 2025, where students were protesting regarding, their law students were protesting regarding issues surrounding final exams. And more recently, law students protested the removal or the rescinding of an offer of a law dean at the University of Arkansas. It's especially a, a vulnerable issue for law students who are engaging in protest. Consequences for them, in some instances, have led to rescinding of jobs, for example. And then other consequences that we've seen. A former prosecutor protested over one of the law firms who entered into a deal with the administration to provide pro bono legal services when after the administration issued a series of executive orders targeting large law firms. And that lawyer was arrested over that protest on the street corner in front of Skadden Arps. And as I said, consequences for law students. Here's an example of a law firm rescinding job offers to law students in the context of their protest efforts. Other consequences can include potentially threats, physical threats of harm, and of course, consequences related to maintaining one's law license or being able to obtain it in the first place. And then I want to also just note has been in recent months, this year in particular, a a question amongst the public of what constitutes a protest. Um, I'm not here to debate that. I'm just here to acknowledge the reality that there have been efforts to recharacterize the January 6th storming of the Capitol as a peaceful protest. And again, I'm not here to debate how we're going to describe what happened, but I want to point out that lawyers were involved in that riot, in that storming of the Capitol. They may have believed that they were involved in a protest. One in particular, the example I have here from William McCall Calhoun, he was convicted for his involvement in it. Certainly it was not perceived to be involvement in a political protest, at least not unlawful involvement. He was convicted. And I'll come back in a few moments after I make a few comments about professional conduct rules to talk about what happened with his law license. It was suspended following that conviction, but stay tuned because that's not the end of the story on Mr. Calhoun. I want to turn now and talk about some disciplinary cases that have occurred in the wake of January 6th in particular. And that will be a way for us to then dive into professional conduct rules that have some bearing on when lawyers can protest, when they might face discipline. And I'll also importantly point out some gray areas where we don't have good guidance, where the model rules don't really give us the parameters we need. Your California rules don't either. And that will set up our conversation for ideas about reform potentially to address those gray areas. But first, let me offer now some examples of consequences, disciplinary cases that came out of, in particular, January 6th, which however we want to characterize it, however one may want to, it might have started as a protest, but it certainly ended in a violent, tragic riot. And there were consequences for the lawyers involved, Mr. Calhoun, who I just mentioned, and others. Two that I want to focus on now are two that surely you have seen in the headlines, especially because one has involved the California Supreme Court and its involvement in John Eastman's disbarment. And then also Rudy Giuliani being disbarred from both New York and Washington, D.C. They are both very prominent examples of the loss of one's law license for their involvement in what may have been efforts to fuel a protest that went tragically wrong. But their discipline was really tied to their role in representing a client. That's especially true with respect to Mr. Eastman. And I am interested in and concerned about the role of a lawyer who is using their platform, their credibility, their authority as a lawyer to speak out to the public and to fuel a protest that becomes violent, even beyond when they are acting in representing a client. And I don't have great examples of that, although I've tipped my hand a little bit because we'll come back to Mr. Calhoun. But let me spend a little bit more time focusing on these two very prominent figures because we have seen that there were serious consequences for both of them in their role in January 6th and also in their efforts to overturn the results of the 2020 election. A few observations. The first observation I have is that there are other lawyers who engaged in relatively similar conduct who haven't faced discipline. For example, Sidney Powell in the state of Texas. And so, where one is licensed may have an impact on whether or not they will face discipline. She, in fact, pled guilty in a Georgia proceeding related to similar kinds of allegations. She was referred by a federal court in Michigan to the Texas bar after that federal court made findings regarding her involvement in efforts to overturn the 2020 election, but she did not face the same kind of disciplinary consequences that we saw for Eastman or Giuliani. So that's my first observation: is the lay of the land can be determined very much based upon the jurisdiction in which a lawyer is licensed. My other observation is how long it has taken for there to be consequences here. It's been years. And to be sure, these two individuals were suspended relatively quickly, but we've only got the final resolution in the Eastman matter just earlier this year. So those are two things to keep in mind as we think about areas where we might need reform. If the goal, and in my view, one goal we should have when we're looking at lawyers who engage in protests is we want to facilitate the ability to protest if it is furthering the rule of law. And we want to hopefully prevent efforts to undermine the rule of law and our democracy. And I'll talk about how we might draw those lines a little bit more specifically in a minute. But now I want to also share the example of Mr. Calhoun because he wasn't representing a client when he engaged in the January 6th riot. In fact, he chose to go on his own and he was suspended from practicing law. And that suspension lasted and has continued. He was ultimately, though, and he pled guilty to violating a provision of the Georgia professional conduct rules. That suspension was in question because he was pardoned for his behavior on January 6th. But the Georgia Supreme Court has rendered an order that has said he should remain suspended from law practice. And so that is one example of a lawyer who has faced a consequence outside of the context of representing a client, but it was attached to pleading guilty to a criminal charge. So that's indeed a very high bar. Before I turn to the professional conduct rules, I want to just say a little bit more about the context we're seeing the use of our disciplinary bodies across jurisdictions to address these behaviors. And again, I'm focused on when lawyers are engaging in protest, but we've seen a heightened number of bar complaints related to lawyers involved in politics across the board from entities like the 65 Project, which was created specifically to bring charges against lawyers who were involved in the election fraud cases. We've also seen more recently efforts related to Department of Justice lawyers. And I mention this because the bar discipline process, I'm not here to say that that is the perfect place for us to address the kinds of concerns I want us to be thinking about here. And in fact, in a slightly different context, not related to lawyers protesting, but in the context of challenging Trump's DOJ and those bar complaints, in this Bloomberg Law article, I said exactly that. I think that bar complaints offer an imperfect tool, but they are what we have. And that brings me to thinking about what the rules of professional conduct provide as parameters. But before I drill down into the specific rules, I want to just raise a few questions for you to have in the back of your mind as we reflect on these rules. First, what animates the rule of law? The idea, and that's what those May 1st lawyers, the lawyers at the courthouse steps in New York City and at the courthouse steps in cities across the country in their suits were protesting last May. They were protesting to support the rule of law. What what animates and informs that? And do lawyers have an affirmative duty to engage in protest or other resistance efforts to preserve the rule of law? Is that something that we all should be doing, whether we're on a street corner or it's a shirt we're wearing or other ways that we engage in resistance? And how do we draw lines? When does a lawyer's role in protest further the rule of law rather than undermine it? And importantly, can ethics rules and norms help cultivate the former, furthering the ability to protest when upholding the rule of law and prevent the latter, undermining it? Lawyers, in many ways, are confronted with the need to reconcile a very unpalatable choice. Um, Especially lawyers who were protesting related to the Department of Justice. How does a lawyer reconcile values that they might feel are compromised if they stay silent, but they might face professional risk if they're speaking out? And how can the rules help protect lawyers who feel the need to speak out in protest? Those are the questions that I think we need to be focusing on. And the rules give us some guidance, not enough, but let's talk about where they do shed light, and then we'll talk about how they might be better informed. And I'll start with the model rules of professional conduct that the ABA has promulgated. Every jurisdiction has a version of them that they have adopted. Now, the ABA has at the beginning of its model rules a preamble. Your California rules don't have this exact preamble, but there is some language that's mirrored in both. And this is language that I think really gets to the heart of some of those questions I just asked. In particular, what is our obligation to engage in resistance if we feel that the rule of law is being compromised? And the language I want to focus on here is in part one of the preamble. A public citizen having special responsibility for the quality of justice. That is one of our obligations. We are not just obligated to represent our clients and to fulfill our duties as officers of the legal system, but we also, as lawyers, are public citizens having a special responsibility for the quality of justice. And comment 6 goes on to state, or provision 6 goes on to state, in addition, a lawyer should further the public's understanding of and confidence in the rule of law and the justice system, because legal institutions in a constitutional democracy depend on popular participation and support to maintain their authority. This is certainly a place in the model rules where a lawyer who believes she should be out engaging in protest to support the rule of law would be able to ground her ability as a lawyer to do so and to do it in her capacity as a lawyer and not just as a private citizen. And in fact, there is at least one scholar who has argued that this compels all lawyers to engage in protest. I think that probably goes a bit too far, but this certainly calls us to be mindful of our obligations beyond just our role as serving clients and as officers of the court. We do have broader obligations. Another rule that is, I think, one that can give some guidance in terms of parameters. So if the preamble gives the ability to engage in protest, 8.4 tells us when you've gone too far. And California has a version of this as well. It's professional misconduct for a lawyer to violate the professional conduct rules, commit a criminal act that engages on the lawyer's honesty, trustworthiness, or fitness as a lawyer, engage in conduct involving dishonesty, fraud, deceit, or misrepresentation, or engage in conduct that's prejudicial to the administration of justice. And these provisions all could bear on a lawyer who is engaging in a um, a protest or an activity that is something like a January 6th that becomes a riot that is fundamentally undermining a core aspect of our democratic government, which is the ability to certify a valid election vote. This rule, though, is very difficult for disciplinary authorities to enforce. And it's somewhat rare to see it alone. Often, when you see a lawyer disciplined for 8.4, it's attached to other rules of professional conduct. I'll just show you quickly the California rules that are similar to what I just shared from the ABA. So again, while California doesn't have that preamble, in Rule 1.0, we do see this acknowledgement of a lawyer as a public citizen having special responsibilities for the quality of justice. And then also similarly, California has an 8.4 that covers the same provisions and then a bit more than the ABA rule. What you're looking at now is actually from a law review article that I have written that will be out in June next month. It's forthcoming in the Michigan Law Review. It's of the same title as the CLE When Lawyers Protest. And in that article, I've created what I'm calling a taxonomy of lawyer protest under the model rules and thinking about the different ways that a lawyer can engage in protest and the rules that would cover it and what risks there might be for a lawyer. And I've already talked about these and given you a bunch of examples both of lawyers engaging in protest as a representative of a client, and then also on their own as public citizens. And we can imagine other examples of the ways that lawyers might, in fact, engage in protest, whether as a client representative, you're advising the client, you might be thinking about impact litigation, statements to the media, who are selecting as a client. And if the lawyer is stepping out in their own role, engaging in the protests themselves, it might be marches, sit-ins, boycotts, media statements, or maybe resigning from the job or giving up one's law license. So those are all different ways that a lawyer can either be acting for a client or be acting on their own. And when acting for a client, we do get a little bit more guidance from Model Rule 1.2, which provides some cover for lawyers who are engaging in counseling and civil disobedience. There's less guidance for that beyond the role of a client representative. As I mentioned, I think the best we can get, it comes from the preamble or Rule 1.0 in California, the notion of a lawyer as having special responsibility for the quality of justice and the public citizen. And then the sort of how far can you go? You certainly can't violate the provisions of 8.4. When we think about the First Amendment and different kinds of constraints on lawyer speech, and this is where I want to go next. We know in the context of representing a client there are lots of constraints on our speech, right? We can't bring a claim in court unless it's a meritorious claim. We must have candor to the tribunal. I'll say more about each of these rules in just a second. There's a rule, on trial publicity, which you could say, truthfulness in statements to others. We don't have those same kinds of constraints when we are acting as officers of the legal system or public citizens outside of representing a client. And we certainly don't have those kinds of constraints on us if we are acting as a private citizen. In terms of risks that lawyers must think about, I've already touched on a number of these in giving you the real world examples, but just as a reminder, can range from state bar discipline, court sanctions, you could compromise your career, could be the loss of a job, the inability to get a job, and increasingly physical safety threats and other harms. Let me say a little bit more about the rules that give some guidance in the context of client representation, and then I'll talk about where we might see the rules reformed to give us more guidance beyond. So ABA Model Rule 3.3 and California's Corollary 3.3 governs candor to the tribunal. And this rule says a lawyer shall not knowingly make a false statement of fact or law, and a lawyer shall not offer evidence that the lawyer knows to be false. So this is clearly in the context of before a court or a proceeding. This would not apply and does not apply in the context of a lawyer who is at the podium in a protest and not speaking in front of a court. Here, this duty of candor owed before a tribunal, if we think back to the example of Giuliani, this rule played a critical role in court. And in fact, a judge directly questioned him in one of the election fraud cases, and he backed away from making the kinds of statements that we saw him make publicly to the media, whether on January 6th or in other instances. And so, a question that I would pose for all of us to think about is if there are instances where we would want to require the same level of candor of lawyers that they must follow in the courtroom when they are speaking in the court of public opinion. Another rule that, again, governs lawyers in the context of client representation that could be helpful outside of it, but wouldn't apply in the context of simply engaging in a protest activity is Rule 3.1, meritorious claims and contentions. And similarly, 3.1 bars lawyers from bringing frivolous claims in court. And what I would say here, so we also have Rule 11 of the Federal Rules of Civil Procedure, also provides or warns, protects against frivolous claims. And it provides that withdrawing frivolous claims within an appropriate time will give a safe harbor to avoid sanctions. But there's not a similar safe harbor in the professional conduct rules. And I think that's worth noting because another important aspect of, to the extent we're going to use the lawyer discipline process to address when lawyers engage in protests that is undermining the rule of law or democracy. We need to have those proceedings play out with a final resolution. That was really important in the context of the very public discipline of Giuliani and Eastman and others. And so one reform that disciplinary bodies could consider and should consider is really built into Rule 3.1, which is not ending a disciplinary proceeding, even if a lawyer would withdraw a claim that they made in the court of public opinion or correct it. Again, right now, there's no requirement for that, but it's something that is at least worth thinking about, whether it would give us more parameters, both safe harbors for lawyers, but also a way to address when lawyers are protesting in ways that undermine the rule of law. Another rule to just address briefly is Rule 4.1, truthfulness in statements to others. And this, of course, protects against making a false statement of material fact to or law to a third person. Both the ABA and the California rules are similar, but this is, of course, also cabined only in the context of representing a client. It wouldn't apply to a lawyer who is making the same kind of statement, not in the courtroom, but instead in the court of public opinion. And when we're thinking about the consequences in the court of public opinion, it's worth considering some of the language in the opinion involving Giuliani's discipline in New York. And there the court said this: a hallmark of our democracy is predicated on free and fair elections. False statements intended to foment a loss of confidence in our elections and resulting loss of confidence in government generally damage the proper functioning of a free society. And here's a language that I think really goes to the heart of the argument I'm making about if we require lawyers to engage in a certain level of factually grounded statements in the courtroom, should we also require that in the court of public opinion? And here's what the New York court had to say about that. When those false statements are made by an attorney, it also erodes the public's confidence in the integrity of attorneys admitted to our bar. So that impacts all of us, right? Not just the attorney who is engaging in making the statements. So for those of us who are out there thinking, oh, we're never going to engage in protest, none of this applies to me. Well, it actually does, because it impacts how we as a profession are perceived. And the court goes on to say, and damages the profession's role as a crucial source of reliable information. And let me just add and emphasize that we are a crucial source of reliable information in an era of increasingly challenging atmosphere to navigate what is true and what is false, whether we're talking about deep fakes or you know alternative facts or whatever is coming through social media or a hallucination through generative artificial intelligence. Like, we have professional rules that make us a crucial source of reliable information that are applied in our courtrooms. And it could be beneficial to think about in limited contexts, but important contexts like the ones I'm talking about today, to extend that out when we are shaping the public's knowledge of law. And the court went on to say this: it tarnishes the reputation of the entire legal profession and its mandate to act as a trusted and essential part of the machinery of justice. The court also said one only has to look at the ongoing present public discord over the 2020 election, which erupted into violence, insurrection, and death on January 6, 2021 at the US Capitol, to understand the extent of damage that can be done when the public is misled by false information about the elections. And that really is at the core of what I'm trying to address in this presentation and also in my writing about when lawyers protest, is how can we, as a profession that is charged with duties to bring forward reliable information, how can we counteract efforts like what we saw on January 6th? Let me also just share some language that came from the Eastman case just April 15th, with the Supreme Court ordering the permanent disbarment of Mr. Eastman from practice of law in California. And this is language that came from the state bar chief trial counsel. And in particular, I want to highlight the concern at the heart of the discipline and his disbarment, which was his effort to mislead courts, public officials, and the American public. And so if we are concerned about lawyers bringing fact-based, reliable information in our courthouses, should we also not be concerned about them doing the same thing when they go out publicly into the court of public opinion and shape the knowledge base for the people, the citizens who trust the legal profession and trust the judiciary to uphold the rule of law? So I have already talked a little bit about Mr. Calhoun, the lawyer who was involved in the January 6th riot at the Capitol. And I just want to emphasize earlier this year, despite his pardon for the criminal activity, the Georgia Supreme Court said that it would be appropriate for him to still be disbarred. And this was a recommendation made, even though what they had been asked to consider was changing his discipline from a suspension to simply a public reprimand, given that he had been pardoned. And I think it's worth emphasizing this. So he was disciplined under Georgia's 8.4. You already saw it, the ABA 8.4 and the California 8.4. Here's the provision that he was disciplined under. And it was attaching very much to a criminal act that he had pled guilty to. But even with that being the source of discipline, and even after his pardon, the Georgia Supreme Court said that they felt a public reprimand was not sufficient and that he should be permanently disbarred. That to me is another example of the same justifications seen in the examples I just saw or showed you from the language from both the Eastman outcome and the Giuliani outcome in New York. One other thing I will just note, though, in the context of Eastman's conviction, so he was convicted, as you may well know, of 10 of 11 counts that were brought against him. And those counts included the failure to support the Constitution, misleading a court, so the rules that we talked about where lawyers cannot mislead the court, misrepresentation and false statements, moral turpitude, proposing unlawful action to the vice president. Though one count that he was not convicted of in the more than 100-page opinion written by Judge Yvette Rowland was the last count, count 11, which involved provoking the Capitol attack. And that does sort of get to my question about how should a lawyer be disciplined if they are in the court of public opinion in speaking in ways that they would not be allowed to in a courthouse. And so I don't know. It's an open question to me whether or not a model rule that extended the duty of candor outside of the courtroom to the court of public opinion would withstand scrutiny. But that doesn't necessarily mean we shouldn't be thinking about including something like that or other kinds of reforms in our professional conduct rules. To be sure, some of the professional conduct rules that we're asked to adhere to aren't necessarily there to be disciplined. Some are aspirational. I would suggest that the provision I opened with in the preamble is an aspirational provision. And there are others. And maybe there's something to be said for even including an aspirational provision. I want to now shift to share some other ideas, emerging scholarship to the extent I have convinced you that something needs to be done to address the gray areas where we don't have strong guidance from the professional conduct rules, which is really any time a lawyer is engaging in protest outside of the context of assisting a client in doing so or advising a client in doing so, how or whether professional disciplinary bodies should have jurisdiction over a lawyer's speech in those kinds of contexts and what we might want to see in place in addition to a duty of candor in the courtroom, having that extended beyond, or might there be other reforms? And so here are a few different pieces that I will recommend to you if you want to think more about the question of reforms and how we respond to the gray area. And I've laid them out on this slide from your left. I would say these are the most robust proposals from reform, and then moving over, of course, my book is in the middle, and then to the right, I would say are pieces that would caution against it. Let me say just a little bit about each one. So, Professor Margaret Tarkington, in her piece, Lawyers and the Abuse of Government Power, she argues for an entirely new professional conduct rule that would govern and place heightened responsibilities on lawyers who are working for the government or lawyers who are representing government officials. And so she attaches additional responsibilities, heightened obligations with respect to duty of candor and beyond, also duties in advising for lawyers who are in the roles of advising a government actor, again, whether they are working for and employed by a governmental body, or like we saw in the case of Mr. Eastman and Mr. Giuliani, they are private lawyers who have been hired to give advice to a government official. And so you can take a look at her piece in the University of Michigan Journal of Law Reform, which contains the the full rule and the justifications for it. I think that she is one of the leading voices, one of the strongest voices out there for aggressive reform to our professional conduct rules to lawyers never again engage in the kind of um, activity that we saw with respect to the 2020 election. And then I will just go over to the opposite side, on the other side of the scale, if you will, a piece from Rebecca Roiphe. She's a law professor at New York Law School. She makes the exact opposite argument. She actually argues that Trump's lawyers should not have been disciplined. She served as an expert witness for Mr. Eastman's case, supporting his case. And she makes strong arguments for why the lawyer discipline system is vulnerable to politicization and weaponization and is not the right place to address how we can get to the concern that I am really focused on, which is professional conduct rules that further and allow for and provide for lawyers to engage in resistance or protest activity that furthers the rule of law, but protects against those who would undermine it. And so I share both of those examples because I will just say there is a robust scholarly debate across the spectrum on what is the proper role for our professional conduct rules here. I view myself as falling in the middle. It's not lost on me that the cover of my book has the scale sort of equally weighted. And I've given you an excerpt from this book in materials that I made available for this to support this presentation. Uh, I, I think that my proposal of contemplating a heightened duty of candor in certain circumstances when lawyers are advancing positions in the public opinion that they in the court of public opinion that they clearly would not be able to in the courthouse, that it could be an important rule that would go to maintaining our credibility as a profession for being a reliable source of information that the public can go to at a time where it's increasingly difficult to know where one can get trusted information. And that to me would be the motivation behind this sort of reform. I'll also just recommend to you Lawyers in Backsliding Democracy by Professor Scott Cummings at UCLA. He has a number of ideas for reform, including highlighting some things that are already happening in California. For example, expedited proceedings for lawyer discipline and these kinds of contexts and that sort of thing. And then the last piece that I've included here on the opposite side of the screen, an unreliable reporter, is a cautionary piece from Professor John Lee at the University of Oklahoma. And in this piece, he raises a concern that in particular, the example he is focusing on is lawyers in the Department of Justice who may be feeling pressure to refer other lawyers to the disciplinary system when it's not warranted. And so it's, again, a cautionary note in that the lawyer discipline system is certainly not a perfect tool for addressing these issues. and there has to be caution in how it's used so that it's not politicized. But I've hopefully offered you some examples today of how it has played out in very controversial cases. The three that I've focused on predominantly, coming from California, Eastman, from New York and DC, Giuliani, and then Georgia, Calhoun, show what has happened in the context of three very extreme examples. But just because they're extreme examples doesn't mean that there aren't lessons for us to learn and for bar authorities to learn. And in particular, lessons for us to contemplate as a profession when we ask, even if, look, I will admit, I'm not one of the lawyers who was in my suit out protesting on May 1st. That's not something that I feel um, called to do as a member of the legal profession, although I respect the decision of those who did. But whether you're out protesting or not, we all have an obligation to understand and think seriously about how the public views the legal profession, especially at a time where, as I've said, it's increasingly difficult to obtain reliable information and to especially discern what we must when it comes to fundamentals of how our democracy should not just function or survive, but also thrive. I will wrap things up now, again, with a final pitch of my proposal, which is extending the candor toward the tribunal, perhaps a bit more broadly out to the court of public opinion, at least when it comes to issues related to certainly election results. And perhaps we can think of some other contexts that would go to undermining the very institutions that uphold our profession in the judiciary. And then lastly, I will just say that if any of you are interested in learning more about the way that I am thinking about these issues and how I am trying to better understand our obligation as lawyers in a time of what I think is fair to say has been democratic stress, I write a Substack called the Legal Ethics Roundup. On it, I maintain a legal ethics and democracy tracker, and it's really just an information collection source where I gather not just information about lawyers protesting, but lots of themes related to lawyers and democratic stress at this time, and challenges to the legal profession, challenges to the judiciary. And then each week on Mondays, I send out a roundup of the headlines. And I really try to just gather the news that you need to know. I'm reading it so that you don't have to. You can just glance through and stay informed. So I would welcome you to join the readership at the Legal Ethics Roundup if these issues are of concern to you. And now I'm happy to turn to questions. And I have not been monitoring the chat. I'm going to stop sharing my PowerPoint though and see if I can take a look. Ah, the question there is, where's your Substack? And I just gave it to you. So that's great. That's an easy question to answer. I love it. So thank you for that. And let's see. I think, all right. So I'm not seeing questions come through. So I'm a law professor, so I can cold call on myself. And what I will do, I think we have just a few minutes remaining, is I will answer a question that I think I I should have answered for all of you, and someone should have asked me about it. Um, and it's to push back a little bit on how we could constrain a lawyer who wants to speak out in the court of public opinion and to require them to ground any statements in the same kind of actual fact and law that they're required to adhere to in the courtroom. And sometimes I get pushback on this. Is this viewpoint discrimination? Doesn't the First Amendment protect this kind of speech? And so let me just offer a few thoughts to wrap up our time together with respect to how the First Amendment plays out in the recommendations that I've put forth today. So I would say, with respect to being viewpoint discrimination, really this distinction for me here is role-based and conduct-based, and discipline would turn on falsity, bad faith, abuse of legal authority, not ideology. And the First Amendment has always tolerated some regulation of professionalized false or misleading speech in institutional functions in the courthouse. And so it seems that that could be a possible legitimate way to extend. And that extension for me would be very narrow. So if another question might be, who decides who undermines, what constitutes undermining the rule of law? This, again, would have to be very narrow objective criteria, knowing falsity, abuse of process, and intent to subvert lawful authority. A mere disagreement with the courts, a disagreement with doctrines, a legitimate, challenge to a law that is the kind of challenge that we see lawyers bring all the time, whether it's civil disobedience or because there are reasonable questions about what a law means, that would all be completely off limits. So this would have to be extremely narrow in terms of um, what the law would require and how it would be enforced. Another concern might be, would this chill protest? And to that, I would say only if framed broadly. If it's properly cabined, it allows for all kinds of disagreement and debate and robust conversation to occur, and that's what we want. We certainly want that. It's what our democracy was founded on. So again, what I would be advocating for is very narrow, but I don't think sometimes the argument is, look, isn't counter speech sufficient to address speech that is false or misleading in the public sphere? Uh, counter speech is certainly essential, but it's not sufficient in moments of rapid institutional harm. I mean, it was not sufficient in the context of January 6th. And I think even to this day, we see members of the public who don't believe that the results of the 2020 election were legitimate, and hearing the arguments on the other side hasn't brought that forward. And so counter speech alone might not be enough in this very limited context. Similarly, criminal law is, I think, arguably not enough. And the best example of that is really from the Georgia Supreme Court, where certainly, to be sure, criminal law punished the violence that occurred. Mr. Calhoun, um, was criminally charged and pled guilty. And so it was criminal law that covered that behavior. But even once he was pardoned from that behavior, the Georgia Supreme Court said, no, our professional conduct rules, legal ethics, that is it covers a different kind of harm. And we think that it should still be enforced here, that this individual has lost their ability to practice law. And sometimes that may, in fact, be the appropriate consequence. I remind my students all of the time that there's the practice of law is a privilege. It's a profession that you earn your ability to be a part of. And if you don't want to follow the rules of professional conduct that we must adhere to, then one can choose to not be a lawyer anymore. And I think that reflects how the Georgia Supreme Court viewed the outcome of that case. Um, the last thing I will say as we're wrapping up and we're coming to the end of our hour is that this project for me is really about preserving the institutional conditions that make democratic disagreement possible. And so I'm not trying to police political beliefs or silence anyone here, but instead to protect the very institutions, both the courthouse and the court of public opinion, that allow for robust, informed debate about the issues of the day to come through. So I thank you all for the opportunity to speak about this topic. As I've tried to say throughout, I hope I've made the case that even if you aren't planning on heading out to the street corner with a picket sign and engage in protest as a lawyer yourself, the fact that our colleagues feel at this time that they are compelled to do so repeatedly. I'm sure that the headlines I shared with you at the opening of my remarks are not the end of the story. That should be of concern to all of us. And every single one of us has an obligation to our profession to ask how we should be supporting and also um, really holding accountable our colleagues so that we are, in fact, making sure the public is informed of actual facts and the actual law so that robust and healthy debate can take place. And thank you.